In January of 1865, a labourer died at his residence near Sunderland, and the cause was recorded as gastric fever. It was 7 years before anyone suggested otherwise. The woman later accused of causing that death, and of causing several others across the 2 decades that followed, was Mary Ann Cotton. She was 32 years old at the time of that first death, and she was the man's wife. Sunderland in the 1860s was a town built on the River Ware, its economy resting on shipbuilding, coal exports, and the labour of men who worked the docks and the collieries surrounding it. Terraced housing ran in close rows near the river, built quickly and cheaply to accommodate a growing labouring population. The Sunderland Royal Infirmary stood as one of the town's principal institutions, treating the injuries and illnesses common to a port and colliery district. County Durham beyond the town was a landscape of coal, its villages arranged around pit shafts and coal staiths, its towns connected by the railway lines that carried the coal to the coast. It was in this district, among labouring families dependent on burial clubs and small insurance policies to guard against the cost of a funeral, that Mary Ann Cotton lived the whole of her recorded life. The record places her, over the following years, in Sunderland, in the smaller harbour town of Seaham, and in the colliery village of West Auckland, moving between households and unions with a frequency that would later draw scrutiny. Mary Ann Cotton was born Mary Ann Robson on the 31st of October 1832 in the village of Low Moorsley, County Durham. Her father, Michael Robson, worked as a coal miner. Her mother, Margaret Robson, is recorded under that married name. The sources do not agree on her maiden name, and none is asserted here. Michael Robson died in a mining accident, a fall down a pit shaft, while his daughter was still a child. Her mother remarried in the years that followed. Mary Ann entered domestic service in her teenage years, the ordinary occupation for a girl of her background and district, and at some point in early adulthood, she trained and worked as a nurse, an occupation to which she would return more than once across her life. In 1852, she married William Mowbray, a labourer who found work in railway and colliery-related employment. The marriage lasted 13 years, during which the couple relocated more than once, following Mowbray's work across the country, before settling again in the Sunderland district. Multiple children were born to the marriage. The record establishes that most did not survive infancy, a fact this account states once, and does not develop further, in keeping with the treatment such deaths are given throughout this record. William Mowbray died in January of 1865, the death with which this account opened. A local doctor attended him and certified the cause as gastric fever, a diagnosis common in the period and one whose presenting symptoms, vomiting, abdominal pain, and prostration, closely resembled the effects of arsenical poisoning. No inquest was held. Following his death, Mary Ann Cotton collected a payment from a burial society or insurance arrangement connected to her husband, recorded in contemporary accounts at approximately £35, a substantial sum against the ordinary income of a labouring household. If you value cases preserved through court records, testimony, and verified documents, follow or subscribe wherever you're listening. Now back to the record. Within months of Mowbray's death, Mary Ann Cotton married again. On the 28th of August, 1865, at the parish church of Monkwearmouth, she married George Ward, a labouring man employed at the docks and shipyards of Sunderland. Little in the surviving record establishes George Ward's character or personal history beyond his occupation and the circumstances of his death. During the period of this marriage, Mary Ann Cotton was employed at the Sunderland Royal Infirmary as a ward attendant, an occupation that placed her in direct proximity to medicines and to substances used in clinical treatment, a documented circumstance relevant to the means by which the later deaths in her circle were accomplished. The physician who attended George Ward in his final illness gave evidence at the time that Ward had appeared in reasonably sound health prior to the onset of the illness that killed him, a circumstance that occasioned some local remark, but did not, at the time, prompt formal suspicion. George Ward died on the 21st of October, 1866, at Sunderland. As with Mowbray, the cause was certified as an illness consistent with gastric fever, presenting with vomiting and stomach pain preceding death. No post-mortem examination was conducted. Mary Ann Cotton benefited from insurance connected to Ward and from provision made under his will, though the exact sums are not established in the surviving record with the same precision as the Mowbray payment. The following year, 1867, brought a third union, though this one did not end in death. Mary Ann Cotton entered the household of James Robinson, a foreman at a Sunderland shipyard, whose wife had recently died, initially in the capacity of housekeeper for his children. The relationship became domestic and marital in character. James Robinson is a documented exception in the pattern of Mary Ann Cotton's unions in two respects. He declined, when the matter arose, to take out a life insurance policy naming her as beneficiary. And he did not die. Instead, Robinson grew suspicious of Mary Ann Cotton's conduct within the household, having discovered that she had made withdrawals from his bank account without his knowledge and had pawned items of household property without his consent. Robinson acted on that suspicion. He ended the relationship and required her to leave his household. The record does not establish that he suspected her of anything beyond financial dishonesty at the time. The significance later attached to his survival rests on the pattern established by the men who did not refuse her and who did not live. In the interval surrounding this period, in early 1867, Mary Ann Cotton travelled to Seaham Harbour, a smaller colliery and harbour town on the Durham coast, to nurse her mother, Margaret Robson, who was in poor health. Margaret Robson died within approximately 9 days of her daughter's arrival. The cause was recorded, in the loose terminology common to the period, as a gastric or stomach disorder. Her mother's prior frailty is documented, and this is noted plainly. Unlike some of the deaths that preceded and followed it, this death did not present as a sudden decline in a person previously in good health, and it drew correspondingly less contemporary remark. By 1870, Mary Ann Cotton had entered the household of Frederick Cotton, a pitman employed as a colliery engineman in the village of West Auckland in southwest County Durham. Frederick Cotton was a widower, supporting a household that included children from his first marriage, and he was also, at the time Mary Ann Cotton entered his household, connected to his unmarried sister, Margaret Cotton, who had, until then, kept house for him. The record establishes that Mary Ann Cotton's involvement with Frederick Cotton began while his sister was still living, and that the period covering her arrival in the household, the death of Margaret Cotton, and her marriage to Frederick Cotton followed one another closely. Mary Ann Cotton and Frederick Cotton married in September of 1870. The marriage was later established to have been bigamous. The surviving sources do not agree precisely on the mechanism, some indicating an earlier union not properly dissolved, and this account asserts only that the marriage was subsequently found to be bigamous without further specifying the legal basis. Margaret Cotton, Frederick's sister, died in the course of 1871. She was unmarried and had kept house for her brother before Mary Ann Cotton's arrival in the household. Her death followed a period in which Mary Ann Cotton had become aware that Margaret Cotton's will named Frederick Cotton as a beneficiary to the sum of £60, a sum which, under the law and custom governing a wife's position at that date, would in practice pass to Mary Ann Cotton as Frederick's wife. The cause of Margaret Cotton's death was recorded, as with the earlier deaths, as an ordinary stomach or gastric illness. Frederick Cotton died on the 20th of September, 1871, at West Auckland. The cause was certified as gastric fever, described in some records as typhoid hepatitis, The same broad and imprecise diagnostic category applied to the earlier deaths in Mary Ann Cotton's circle. Frederick Cotton held a life insurance policy with the British and Prudential Assurance Company, taken out around the time of the marriage, and Mary Ann Cotton benefited from this policy following his death. The final adult death associated with Mary Ann Cotton's household was that of Joseph Nattrass, a joiner by trade, aged 35, who had known Mary Ann Cotton earlier in her life, and who, in the latter part of 1871, moved into her household at West Auckland as a lodger, in a relationship the record treats as a documented liaison rather than a concealed affair. Shortly after moving into the household, Joseph Nattrass revised his will to name Mary Ann Cotton as a beneficiary. He died in the early months of 1872. Mary Ann Cotton collected approximately £30 in insurance following his death. Across these unions and deaths, spanning 1865 to 1872, a financial pattern recurs consistently in the surviving record. Burial clubs and small life insurance policies were an ordinary feature of working-class provision in this period, intended to guarantee a proper burial rather than a pauper's grave, and nearly every household in the district of a similar economic position held some such provision. In the case of Mary Ann Cotton's households, each death was followed within a documented interval by the collection of a payment connected to that death. Mowbray's death yielded approximately £35. Ward's death yielded provision under his will and insurance, the precise sum not established with the same clarity. Frederick Cotton's death yielded payment under the British and Prudential policy. Margaret Cotton's will provided for a sum of £60 to pass, through Frederick, into the household. Nattrass's death yielded approximately £30. No single payment, considered alone, was unusual. Burial provision of this kind was ordinary. The pattern lay in the frequency with which death in this particular household was followed by payment across 6 adult deaths over 7 years, together with the household deaths that fall outside the scope of this account. The purchase of the substance later found responsible for these deaths is documented in the surviving trial record. Arsenic in this period was cheap, in wide legitimate use for the destruction of household vermin, and available for lawful purchase under the terms of the Arsenic Act of 1851. That statute required a purchaser to sign a poison register, and required that a purchaser of arsenic in its plain or uncoloured form be either known personally to the seller or introduced by a witness known to the seller. These requirements applied with less rigour to arsenic sold in compound form, mixed with soft soap, a preparation marketed for the killing of bedbugs and sold widely as an ordinary domestic product. It was this compound that the trial record establishes Mary Ann Cotton purchased on more than one occasion. On at least one documented occasion, she attempted to make such a purchase under a false name, giving her name to the chemist's assistant as Mary Ann Booth. The pattern of illness that preceded each of these deaths is documented with consistency across the surviving record, though the finer domestic detail, the day-to-day observations within each household, is not preserved with equal richness for every case. In general terms, the person who would die had been in apparently ordinary health in the days or weeks preceding the onset of illness. The illness itself presented as a severe disturbance of the stomach, marked by vomiting, abdominal pain, and a progressive prostration, a weakening of the body that left the patient unable to rise or take nourishment. This decline typically extended across a period of some days, and in certain cases closer to 2 weeks, before death occurred. In each household, Mary Ann Cotton was recorded as the person who nursed the dying, who prepared the food and drink brought to the sick room, and who was present at the bedside in the final hours. A local physician attended in each case, and in the absence of any circumstance to suggest otherwise, each physician certified the death using the diagnosis then in common use for such symptoms: gastric fever, a term broad enough to cover a wide range of genuine intestinal and infectious illness, common in Victorian households, and one whose presenting profile, as later toxicological understanding would establish, was difficult to distinguish from the effects of arsenical poisoning without direct chemical testing. No inquest was convened, and no post-mortem examination was performed, following any of these 6 adult deaths at the time each occurred. Burial followed in the ordinary course, in each case accepted without formal question by the parish and civil authorities responsible for recording it. The pattern that had held for 7 years, across 2 towns and a colliery village, and across 4 documented unions, and a lodger's tenancy, was broken in the spring of 1872 in the household Mary Ann Cotton kept at West Auckland. A death occurred in that household in this period which, unlike the 6 that preceded it, was not accepted without question. This account states once the bare fact required by the record. The death that first drew formal suspicion was that of a child in the household, the stepson, Charles Edward Cotton, and this account does not describe him further, name him again, or dwell upon the death itself. The person who first raised that suspicion was Thomas Riley, an official connected to the local workhouse and parish relief system in West Auckland, whose duties in a colliery village of this size gave him direct and personal familiarity with the households in his district. Riley had prior dealings with Mary Ann Cotton in the weeks before the death, in the course of which she had raised with him the question of placing a child from her household into the workhouse, a conversation the record preserves only in outline. When the death in the household followed so soon upon a period Riley understood to be one of ordinary health, he did not accept the matter as settled. He raised the question with the local registrar responsible for recording the death, and he communicated his suspicion to the police. Riley is recorded as having stated, in substance, that he would not let the matter pass without further inquiry, a position that ran directly against the ordinary practice of accepting a local doctor's certificate without challenge. This refusal delayed the registration of the death and the arrangements for burial. Dr. William Kilburn, the physician who had been in attendance, withheld the certificate that would ordinarily have closed the matter, pending further examination. This was the pivot on which the case turned. 6 deaths across 7 years had passed without a single formal question raised against them. The 7th drew one from a parish official whose position gave him the standing to insist on an answer, and whose refusal a local doctor was prepared to support. In the interval between Riley's report and the post-mortem examination that followed, Mary Ann Cotton remained in West Auckland. She did not leave the district, and the surviving record does not preserve any detailed account of statements she made during this period, beyond the fact of her continued presence in the household. Dr. Kilburn's post-mortem examination of the child's body led to the detection of arsenic, and this finding in turn prompted a wider inquiry into the other deaths connected to Mary Ann Cotton's households. An order was obtained for the exhumation of Frederick Cotton, buried some months earlier, and his remains were examined in the presence of the authorities responsible for the inquiry. The chemical method applied to these examinations was the Reinsch test, developed by the chemist Hugo Reinsch in 1841, and in standard use as the period's principal means of detecting arsenic in organic remains. The test proceeds by immersing a strip of copper in a sample of the tissue under examination, acidified for the purpose, and observing whether a grey or black deposit forms upon the copper's surface, a deposit that indicates the presence of arsenic in the material tested. Professor Thomas Scattergood, an analytical chemist of established reputation based in Leeds, undertook or reviewed the principal toxicological analysis of the exhumed remains. His findings established the presence of arsenic in quantities the prosecution would later characterise as inconsistent with any innocent or environmental source. The toxicological method available in this period could establish that arsenic was present in the tissue examined. It could not, by its nature, establish who had administered that arsenic, or when or under what circumstance, a limitation the record does not obscure, and this account states plainly. The case that followed would rest on this chemical finding taken together with the surrounding evidence of purchase, access and financial benefit, rather than on the toxicology standing alone. Following the post-mortem finding and scattergoods analysis, the Durham County Police took up the matter formally, and Mary Ann Cotton was arrested in 1872 in connection with the death that had first drawn Riley's suspicion. Once the case drew the attention of the local and regional press, the wider pattern of deaths across her marriages and unions came under scrutiny, and the sequence of 6 adult deaths across 7 years, together with the household death that had triggered the inquiry, became a matter of public discussion in Durham and Newcastle, consistent with the ordinary practice of the period, in which a prosecution proceeded on the charge most readily proven rather than attempting to try every death in a single proceeding. Mary Ann Cotton was committed to answer a single charge. The surviving record does not preserve a verbatim statement attributed to her at the point of arrest with the same reliability that attaches to the evidence later given at trial, and this account does not repeat any such purported statement as established fact. A coroner's inquest was convened in West Auckland in 1872 to inquire into the household death that had prompted Riley's report and Kilburn's examination. Medical evidence of arsenic poisoning was placed before the inquest jury, drawing on the findings of the post-mortem and the early chemical analysis. The surviving secondary sources do not preserve a full witness-by-witness account of the inquest proceedings, with the same detail available for the assize trial that followed, and this account does not invent testimony beyond what the record supports. The inquest jury returned a verdict consistent with willful murder. That verdict had one immediate consequence under the law then in force. It required Mary Ann Cotton's committal to stand trial at the next sitting of the Durham Assizes, the county's Crown Court for offences of this gravity. The trial opened at the Durham Assizes on the 5th of March 1873 and continued across approximately 5 days, concluding on the 7th of March with the jury's deliberation and verdict. Mr. Justice Archibald presided. The prosecution was led by Sir Charles Russell, a rising counsel who would later serve as Lord Chief Justice, appearing here at an earlier stage of a career that had already marked him as a formidable advocate. The defence was conducted by Thomas Campbell Foster. Mary Ann Cotton stood in the dock to answer a single charge, the willful murder of her stepson by the administration of arsenic, and she entered a plea of not guilty. Under the law, as it stood before the Criminal Evidence Act of 1898, a person accused of a felony could not give sworn evidence in her own defence, and Mary Ann Cotton did not testify at any point in the proceedings that followed. Sir Charles Russell opened the case for the prosecution by setting before the jury the sequence of events at West Auckland, the household death that had prompted Thomas Riley's report, and the post-mortem finding of arsenic that had followed. He called the medical witnesses first. Dr. William Kilburn gave an account of his examination of the body and of his decision to withhold a death certificate pending further inquiry, testimony that established for the jury the moment at which the ordinary course of an accepted natural death had been interrupted. The chemical evidence followed. Testimony connected to Professor Thomas Scattergood's analysis was placed before the court, setting out the Reinsch test applied to the remains and the quantity of arsenic the examination had recovered, a quantity the prosecution characterised as far beyond what any accidental or environmental exposure could plausibly explain. Russell then turned to the evidence of purchase and access. Thomas Detchen, a chemist's assistant, was called to testify to Mary Ann Cotton's attempt to purchase the arsenic and soft soap preparation used against household vermin, and to the false name she had given at the time of that purchase, Mary Ann Booth. This testimony carried particular weight before the jury, establishing not merely that arsenic had been present in her household, but that she had sought to obtain it under a name not her own, a circumstance the prosecution argued could not be explained by any innocent purpose. Evidence of the burial club and insurance provision connected to the household was placed before the court in the same portion of the case, establishing the financial benefit that had followed the deaths in question and situating the household death within the same pattern of payment that had attended the deaths of William Mowbray, George Ward, Margaret Robson, Frederick Cotton, Margaret Cotton, and Joseph Nattrass. Evidence the prosecution led as circumstantial background to the single charge before the court, rather than as separate accusations to be separately proven. Thomas Campbell Foster's defence rested on a single central proposition that the arsenic recovered from the body might have originated not from any act of Mary Ann Cotton's, but from the household's own wallpaper. Arsenical dye, most commonly the pigment known as Shields green, had been in wide use in Victorian wallpaper manufacture, and it was a documented hazard of the period that such dye could release arsenic in dust form, particularly where a paper was disturbed through cleaning or affected by damp. Foster argued this environmental explanation to the jury as a genuine alternative to deliberate administration, one grounded in a real and recognised domestic danger of the age rather than invented for the purposes of the defence. Sir Charles Russell's rebuttal proceeded on two grounds. He established, through evidence as to the rooms occupied by the deceased, that several of those who had died in Mary Ann Cotton's households had never occupied, or had only the most minimal exposure to, any room papered with such a dye, a fact that undercut the environmental theory as a complete explanation. And he returned the jury's attention to the direct evidence of purchase under a false name, a circumstance the wallpaper theory could not account for by any reading. Mr. Justice Archibald's summing up directed the jury carefully through both bodies of evidence, the toxicological findings and the surrounding circumstantial case, before the jury withdrew to consider its verdict. The jury's deliberation lasted approximately 1 hour. When the jury returned, the foreman delivered a verdict of guilty. Mary Ann Cotton collapsed in the dock on hearing the verdict announced, and she had to be carried from the courtroom, unable to stand under her own strength. The trial had proceeded, from its opening to its verdict, across 5 days, resting on a case built from chemical analysis, a chemist's signed poison register, the testimony of a workhouse official who had declined to accept an easy explanation, and a pattern of payment that followed 6 adult deaths across 7 years. It had answered, to the satisfaction of a Durham jury, a single charge concerning a single death, and it left the 6 adult deaths that preceded it as the circumstantial frame within which that single charge was tried, rather than as separately adjudicated matters. Mr. Justice Archibald pronounced the sentence of death upon Mary Ann Cotton, following the jury's verdict in accordance with the law as it applied to a conviction for willful murder. The case had already drawn substantial attention from the regional press of Durham and Newcastle in the course of the trial, and in the weeks following the verdict that attention extended to newspapers beyond the county, carrying an account of the case to a national readership. A degree of public sympathy attached to Mary Ann Cotton in this period, driven in significant part by the fact that she was pregnant at the time of her trial and sentencing. A petition seeking a reprieve was raised on her behalf in the weeks that followed the verdict, urging the Home Secretary to intervene and commute the sentence. The Home Office, under the government then in office, declined to act on that petition, and the sentence of death was allowed to stand. Mary Ann Cotton gave birth to a daughter while confined in Durham jail awaiting execution. The child, named Margaret, was taken from her mother's custody and placed for adoption 5 days before the date set for the execution, a fact the surviving record establishes plainly, and which this account states once, without further development, as the child is not among the victims this record is concerned with, and the circumstance is noted only for its place in the documented chronology. The execution was carried out on the 24th of March, 1873, within the walls of Durham County Jail. By this date, executions in England were conducted privately within the prison under the terms of the Capital Punishment Amendment Act of 1868, and no crowd gathered outside to witness the proceeding, in contrast to the public executions of an earlier period. William Calcraft served as executioner, assisted by Robert Anderson. The execution is recorded by the standards later applied to the practice of hanging as having been imperfectly carried out. The drop given was short, and death did not follow from the fracture of the neck that a longer and more carefully calculated drop was intended to produce. Mary Ann Cotton is recorded as having struggled for a period estimated at approximately 3 minutes before death occurred, a consequence of strangulation rather than a swift breaking of the neck. Before the sentence was carried out, she is reported to have told a prison minister that she might have killed the boy, a statement the surviving record treats as an ambiguous near admission rather than a clear and unqualified confession, and it is presented here in those terms as the one statement attributed to her with any reasonable claim to reliability. Modern historical examination of the case, most substantially the criminologist David Wilson's study published in 2013, does not treat Mary Ann Cotton's guilt as a matter of serious doubt. The line of inquiry that modern reconsideration has pursued concerns a different question: how a woman was able to preside over so great a number of deaths across so long a period, roughly 2 decades by the widest reckoning, without any of them drawing formal suspicion until the last. The answer that this body of work identifies rests on several converging circumstances documented across this account. Mary Ann Cotton's households moved frequently across Sunderland, Seaham Harbour and West Auckland, so that no single doctor, no single parish, and no single set of neighbours observed the pattern across its full span. The diagnosis of gastric fever, applied without exception to each death, was a genuine and common finding in a period of high infectious and gastric mortality among both adults and infants, and it required no explanation beyond itself. No inquest and no post-mortem attended any of the 6 adult deaths that preceded the household death of 1872, because none of the attending physicians found cause to request one. The honest limitation of the case bears restating in these terms. Chemical analysis in this period could establish that arsenic was present in a body, but it could not establish by itself who had placed it there, and the case has rested throughout on the combination of that chemical finding with the surrounding evidence of purchase, access, and financial benefit, argued to a jury as a single coherent pattern rather than proven death by death. The number of deaths ultimately associated with Mary Ann Cotton across her households is not fixed with precision in the surviving record. Estimates in the secondary literature range from approximately 14 to 21, a spread that reflects genuine uncertainty in the sources rather than a single settled figure, and this account states that range honestly rather than asserting either end of it as established fact. Whatever the precise total, the case as it stood at trial rested on one charge, proven to the satisfaction of a jury, surrounded by a pattern of prior deaths that was never separately tried. The legal position of a married woman in the period covered by this record bears directly on the shape the case took. Before the Married Women's Property Acts of 1870 and 1882, her wife's earnings, her savings, and in significant respects her legal identity were subordinate to her husband's under the law of England. A woman in Mary Ann Cotton's economic position had comparatively few independent means of securing her own financial footing, and marriage, or the ending of one marriage in favour of the next, represented one of the few routes by which a woman in her circumstances could alter her position at all. This account does not offer this as an explanation for what occurred in her households. It offers it as the documented legal and economic backdrop against which the frequency of her unions and the speed with which one followed another is properly understood. The burial, club and small insurance economy that ran through every death in this account was, in itself, an entirely ordinary feature of working-class life across County Durham and the industrial north in this period. Families paid small weekly sums into local societies for the specific purpose of guaranteeing a funeral befitting a family's respectability, sparing them the particular shame, keenly felt in this period, of a pauper's burial at parish expense. The sum such policies paid out, £30, £60, a little more or less, were not large by any absolute measure, but against the weekly wage of a colliery labourer or a dockhand, commonly less than £1, they represented a sum equal to months, or in some cases more than a year's earnings. It was this same ordinary and widespread provision, intended to protect against the shame of poverty and death, that created the perverse incentive later identified in the case, an incentive that operated identically in thousands of honest households across the same towns and villages, and which drew notice in this household only because death visited it with a frequency no other household of the period is recorded as having matched. In the years following the execution, Mary Ann Cotton's case entered the folk memory of the northeast of England in a manner few criminal cases of the period achieved. A skipping rhyme naming her became attached to children's playground tradition in County Durham and the surrounding region in the decades after 1873. A piece of oral culture whose survival across generations is itself evidence of how deeply the case lodged in regional memory. Its content is not repeated in this account, in keeping with the treatment given throughout to material that would centre a child. In the 20th and 21st centuries, the case has continued to draw sustained attention from writers of criminology and true crime, most substantially in David Wilson's 2013 study, which remains the principal modern synthesis of the surviving evidence. In 2016, the case reached a mainstream television audience through the ITV drama Dark Angel, starring Joanne Froggatt in the role of Mary Ann Cotton, a dramatised account that brought the case to viewers with no prior familiarity with the Durham Assizes record. The case continues to appear in surveys of Victorian crime, in academic and popular discussion of the Arsenic Act of 1851 and the burial club economy it was intended imperfectly to guard against, and in true crime documentary and podcast treatment produced internationally, more than a century and a half after the Durham jury returned its verdict. The institutional legacy of the case is more precisely a legacy of illustration than of direct reform. No single act of Parliament is attributed in the documented record to Mary Ann Cotton's case specifically, and the Arsenic Act of 1851, the principal statute governing the sale of the substance used throughout her households, predated her crimes by more than a decade and remained the operative law, imperfect as its safeguards proved throughout the period covered by this account. What the case illustrates, and what it has been cited for consistently in the retrospective literature on Victorian death registration, is the vulnerability inherent in a system where domestic deaths, each individually unremarkable against a background of genuinely high mortality from gastric and infectious illness, could pass across different doctors and different parishes without any mechanism to connect one death to another in the same household over time. It stands in the historical record as the case that exposed the gap between the appearance of 6 or more individually unremarkable deaths and the pattern they formed when considered together, rather than as the case that closed that gap by any named statute or reform. The pattern was seen in the end not by a physician, not by an insurer, and not by the law as it then stood, but by a parish relieving officer in a colliery village who declined to accept an explanation that did not satisfy him. Confidence in the pattern rested in part on numbers that the surviving record sets out with some precision. William Mowbray's payment of approximately £35 arrived at a time when a labourer's weekly wage in the Sunderland district commonly stood well under £1, meaning the sum collected on his death approximated close to a year's ordinary earnings for a household of his class. The £60 anticipated under Margaret Cotton's will represented a still larger figure against the same measure, closer to 2 years' wages for a colliery labourer of the period. Joseph Nattrass's £30, collected within weeks of his death, followed a will he had revised only shortly before, naming Mary Ann Cotton in place of whatever provision it had previously made. None of these sums, taken alone, exceeded what an honest burial club payout of the period might reasonably provide to a grieving household. It was their recurrence, attached to the same household across 7 years and 5 separate deaths beyond the one finally tried, that the prosecution asked the jury to weigh as more than coincidence, without asking the jury to convict on any death beyond the single charge before it. The case of James Robinson, considered against this financial pattern, occupies a particular place in the record. Robinson was a shipyard foreman, a man in steadier and more senior employment than the labourers and pitmen who had preceded him in Mary Ann Cotton's life, and by the standards of his class and district, a man of some independent means. When the question of insurance arose within the household, as it is recorded to have arisen in each of Mary Ann Cotton's unions, Robinson declined to take out a policy naming her as beneficiary. It was in the course of this same union that Robinson discovered withdrawals made from his bank account without his authorization and household items pawned without his knowledge, financial irregularities distinct in kind from anything attempted against the men who preceded him. He acted on what he found. He ended the union and required Mary Ann Cotton to leave his household, and he did not fall ill in the course of their relationship, nor at any point afterward that the record connects to her. The case draws no conclusion from Robinson's survival beyond what the documented facts support. He was the one man among her unions who refused the arrangement that had preceded death in every prior instance and who lived. The exhumation that followed Dr. Kilburn's initial post-mortem finding was not a single or simple undertaking. An order for the raising of Frederick Cotton's remains was obtained through the proper legal channel, and the disinterment was carried out in the presence of the officials whose attendance the law required, so that the chain of possession of the remains from grave to analyst could be established without challenge at trial. The remains, once raised, were conveyed for chemical examination, and it was in the course of this examination, using the Reinsch test, in the manner already applied to the household death, that had first drawn suspicion that arsenic was again detected, in a quantity the analysis concluded could not be reconciled with any natural or accidental presence in the body. This second finding, arrived at independently of the first, did the particular work within the case of demonstrating that the household death of 1872 was not an isolated event, but one instance of a method that had been applied on the evidence of the exhumed remains at least once before within the same household. The scale of the case, once it became known beyond Durham, invited a comparison that the historical record has returned to repeatedly in the century and a half since. No case of comparable scale, a single individual connected to a comparable number of deaths across a comparable span of years, arose again in the criminal history of Britain until cases that emerged in the 1980s, more than a century later. For the whole of the intervening period, Mary Ann Cotton's case stood as the reference point against which any subsequent case of its kind was measured, cited in the criminological and true crime literature as the benchmark example of a killer operating within a domestic setting, undetected across a span of years, through the ordinary mechanisms of Victorian medicine and registration rather than through any exceptional concealment on her part. The Durham Assizes, at which the case was tried, sat within the county town's ancient courts complex, adjoining Durham Castle and within sight of the cathedral that dominates the city from its position above the River Wear, a setting that placed the proceedings at the administrative and judicial centre of the county in which every death in the case had occurred. Durham County Jail stood adjacent to the courts, so that the woman convicted within those walls in March was executed within the same institutional precinct some 3 weeks later, without transfer to any other place of confinement. The proximity of trial and execution within a single institutional complex was, in this period, the ordinary arrangement for a capital case tried at the county assizes, and nothing in the surviving record marks the arrangement in Mary Ann Cotton's case as in any way exceptional. The poison register that Thomas Detchen's testimony placed before the court recorded transactions of a kind repeated many times over in the ordinary business of any chemist's shop in a district built on coal and shipbuilding, where rodents and household vermin were a constant and unremarkable nuisance addressed by lawful and inexpensive means. It was against this backdrop of routine purchase, entirely unremarkable in itself, that the false name given on at least one occasion carried its particular weight before the jury. A single deviation from an otherwise unremarkable pattern of household provisioning that the prosecution asked the jury to read as evidence of a purpose its purchaser wished to conceal. Before the case reached open trial, it passed through the grand jury process required under the criminal procedure of the day, by which a jury sitting in private examined the evidence assembled by the prosecution and determined whether a true bill should be returned, authorising the case to proceed to open trial on the charge presented. The evidence placed before this earlier jury drew on the same post-mortem and toxicological findings that would later be laid before the trial jury, together with the record of purchase and the financial circumstances surrounding the household. The grand jury returned a true bill on the charge concerning the household death, that of Charles Edward Cotton, a name that appears in the surviving record of the proceedings as one line among the formal particulars of the charge, and appears in this account for that reason alone. No true bill was sought, and none was returned on any of the 6 adult deaths that had preceded it, consistent with the prosecution's decision, taken before the case ever reached open court, to try the single charge the toxicological and circumstantial evidence could most directly support. The evidentiary standard that Sir Charles Russell's prosecution had to satisfy was the ordinary criminal standard applied at the assizes. Proof beyond reasonable doubt. An English law of the period permitted a conviction to rest on circumstantial evidence properly weighed, provided that evidence excluded any reasonable explanation consistent with innocence. This was the framework within which the wallpaper defence had to be measured, and within which it ultimately failed, not because arsenical wallpaper dye was not a real hazard of the period, which the surviving record does not dispute, but because the specific pattern of exposure the defence required, exposure sufficient to account for the quantities scattergoods analysis had recovered, could not be established for the rooms and the individuals the case concerned. Mr. Justice Archibald's direction to the jury addressed this distinction squarely, instructing the jury to weigh the general possibility the defence had raised against the specific facts the evidence before them supported, rather than to treat the existence of arsenical wallpaper as a hazard in general use across the country as itself sufficient to raise a reasonable doubt in this particular household. The verdict, once returned, closed the single charge on which Mary Ann Cotton had been tried, and it is on that single, formally adjudicated charge that her conviction rests in the documented legal record. The 6 adult deaths that had preceded the household death of 1872, across Sunderland, Seaham Harbour and West Auckland, over the 7 years from William Mowbray's death in January of 1865 to Joseph Nattrass's death in the early months of 1872, were never separately tried, and no separate verdict was ever returned upon any one of them. They remain in the documented record, part of the pattern the prosecution laid before the jury as the surrounding circumstance of the single charge it proved, a pattern of recurring death, recurring payment, and recurring diagnosis across 2 decades of one woman's domestic life, examined once at trial, and settled by the verdict of a single Durham jury in March of 1873. The system of civil registration then in force in England had been established by statute in 1837, requiring every death to be reported to a local registrar within a fixed number of days and recorded against a cause supplied by the attending physician, or, in the absence of a physician's certificate, by the informant present at the death. Each registrar's district covered a defined and comparatively small area, a single town or a cluster of parishes, and the records each registrar kept were retained locally, forwarded in summary to the General Register Office in London for national statistical purposes, but not cross-referenced at the district level against records held in a neighbouring registrar's district. A death registered in Sunderland in 1865 and a death registered in West Auckland in 1871 were, under this system, entirely separate entries, examined by different registrars, certified by different physicians, and connected to one another by nothing in the machinery of the state itself. The connection between them existed only in the fact of a single woman's presence at both bedsides, a fact no registrar, examining either death in isolation, had any occasion to discover. It was this structural gap, rather than any particular failure of vigilance on the part of any one physician or registrar, that the case exposed most clearly to those who examined it afterward. Each physician who certified a death in Mary Ann Cotton's households acted, so far as the surviving record establishes, within the ordinary competence and diligence expected of a Victorian general practitioner attending a working household. Gastric fever was not a diagnosis reached carelessly. It was reached because the symptoms it named, vomiting, abdominal pain, a progressive wasting and prostration, were symptoms these physicians encountered with genuine frequency among patients suffering from authentic gastric and infectious illness. In towns where sanitation remained imperfect, water supplies were not uniformly safe, and infectious disease carried away adults as well as infants at rates a modern practice would regard as extraordinary. Arsenical poisoning, administered in the graduated and repeated doses the case would later be understood to involve, produced a clinical picture that mimicked this authentic and common illness closely enough that no attending physician, working without cause for suspicion and without access to chemical testing at the bedside, could reasonably have been expected to distinguish one from the other. Chemical testing of the kind Professor Scattergood applied to the exhumed remains required a laboratory, a trained analyst, and critically, a reason to look, a reason that arose in this case only when Thomas Riley declined to accept the explanation offered to him. The Sunderland Royal Infirmary, where Mary Ann Cotton had been employed as a ward attendant during the period of her marriage to George Ward, functioned in this period as one of the principal charitable hospitals of the North East, treating the injuries of dock and shipyard labour alongside the general illness of the town's poor, and staffed by physicians and attendants who handled, in the ordinary course of their duties, the medicines and preparations of a mid-Victorian dispensary. Employment of this kind did not require any special licence to handle substances that, outside a clinical setting, remained available to any householder through the ordinary chemist's trade under the terms already described. What such employment provided was familiarity, an ordinary and unremarked proximity to the handling of medicine and the administration of dosage of the kind a ward attendant acquired simply by the daily performance of her duties, and it is this familiarity, documented as a fact of her employment history rather than inferred from it, that the case places alongside the chemist's poison register as part of the same broader picture of access. The scale of ordinary mortality against which Mary Ann Cotton's case has to be measured was, by any standard now current, extremely high. Infant deaths in the industrial districts of County Durham and Sunderland ran, across the 1860s and 70s, at a rate several times any figure familiar today, and adult deaths from gastric and infectious illness, typhoid, dysentery, and the broad category gathered under the term gastric fever, were common enough in a dock and colliery population that a single death of this kind in a single household drew no particular remark from neighbours or from the parish. This background rate is not offered as an excuse for what a Durham jury found Mary Ann Cotton to have done. It is offered, consistent with the modern historical reconsideration of the case, as the reason the pattern took the shape it did, a pattern legible only in retrospect. Once the deaths across 6 years and 3 towns were set down together on a single page, a page no registrar, no physician, and no insurer had occasion to compile until Thomas Riley forced the question in 1872. The petition raised on Mary Ann Cotton's behalf following her sentencing drew signatures from residents of Durham and the surrounding district, and its argument to the Home Office rested principally on her condition. Then several months pregnant, and on the view, held by some among the signatories, that the single conviction obtained did not rest on evidence so overwhelming as to foreclose all doubt. The Home Office's refusal to intervene was communicated through the ordinary channel by which such petitions were answered in this period, a formal notice that the law would take its course, without further published reasoning attached to the decision. No further legal avenue remained open to her once that refusal was received, and the date already fixed for the execution stood without further alteration. The physicians and officials whose testimony carried the case, Kilburn in his examination of the body, Scattergood in his chemical analysis, Detchen in his account of the poison register, and Riley in the refusal that had set the whole inquiry in motion, were none of them figures of any particular prominence before the case brought them into the record of the Durham Assizes, and the case remains, in the historical literature that has examined it since, as much a study of their ordinary procedural diligence as it is a study of the woman they gave evidence against. It was the accumulation of their separate and unremarkable acts of attention, a workhouse officer who would not sign off on an explanation that did not satisfy him, a doctor who withheld a certificate rather than issue one as a formality, a chemist's assistant who remembered a name given falsely across his counter, that assembled, piece by piece, the case the prosecution carried into court in March of 1873. The sentence was carried out at Durham County Jail on the 24th of March, 1873. The case entered British memory and did not leave it. The record remains in the archive, and it remains disputed.